Our next speaker is Ms. Upuli Karunawardhana, graduate in law from the University of Colombo. She is also an attorney at law of the Supreme Court of Sri Lanka, and currently she serves as a lecturer at the Department of Law, University of Tehran. Her research interests include international law and environmental law. I would like to invite Ms. Upuli Karunawardhana to enlighten us on the topic, significance of access to justice and legal aid, an analysis of concepts and contemporary adjustments.
Thank you, Chair. This is going to be my very first presentation in an international conference, so I expect your sincere support, and as well, if something goes wrong, I'm begging your pardon, right? Okay. So this is about significance of access to justice and legal aid, an analysis of concepts and contemporary adjustments. Okay, because this is extremely important to the today's context of the society. So this paper aims to discuss the concept of access to justice, legal aid, and historical development of access to justice and legal aid as well, and current importance of this particular concept. And it contains collation and comparative analysis of adaptation of this particular concepts. And final outcomes of this analysis will be collation of concepts and analysis, some contemporary adjustments to the system which should be made to make access to justice possible. The literature review, I have basically referred to two constitutions and some enactments, and some reports with, provided by United Nations Development Program, and also basically some instruments with regard to international regime, and this is the literature review of my research. The research methodology is a qualitative one, which is based on library research and internet research. The outline of my paper basically, which I submitted, was about introduction and the historical background and the conceptual foundation of access to justice and legal aid. Legal aid law and access to justice in Sri Lanka, international standards related to access to justice, improvements in access to justice in foreign jurisdictions and contemporary adjustments to the local system, and conclusion. Before referring into the main subject of my research, I would like to pay your attention on this, what is justice basically? Why are we trying to get access to justice? So justice is basically something we can't find a very profound meaning to. It is a Herculean task that we can't find a very exclusive meaning. So we have been very tired of finding this for centuries. But anyhow, the quality of being just, righteousness, equitableness and moral rightness could be considered as generally as justice. But why we are looking for justice this much? Because it is per se, law is per se about justice. That is why we are trying to get access to justice, and why this access to justice concept has become more important, right? Okay. So this is why access to justice as a concept has become this important. Justice, when it becomes a very expensive and burdensome task for people, especially disabled people, due to lack of financial incapabilities and sufficient knowledge what they have, then what happens is they suffer without proper adequate redress or without redress at all. Then the direct outcome of this is basically they attempt to circumvent the law, which is not good at all, and outrageously satisfying their needs through very illegal means. So this is having basically like short-term and long-term results which are very adverse to progress of a country and legal system. The historical background and the conceptual foundation of access to justice and legal aid. And this is a universal concept which we need to keep in our minds, a universal concept. Irrespective of all the disparities, all the states should provide access to justice. And in this definition which is provided by United Nations Development Program, I can identify two different aspects basically about people's ability to solve disputes and reach adequate remedies for grievances using both formal and informal justice systems, which we can call as getting access to justice. And the best part of this definition is the qualitative dimension of access to justice, which is the human rights dimension, which is like though we get access to justice, if the outcome is not equate to provide, sufficient, which is not compatible with human rights standards, will be definitely a very futile effort. So, blossoming of access to justice and legal aid. While time passes, the world realizes some groups of people are very susceptible to getting deprived of their rights from their remedies. So they realized promoting an effective, responsive, accessible and fair justice system became a must. And legal aid as a tool for access to justice, as a tool to sustain their needs basically, to provide free legal consultation and representation at courts. Legal aid was provided, so it made access to justice possible. Legal aid was limited. This is the most pathetic situation. Legal aid was limited for the people who could not pay the market price for legal services and for criminal offences. For the defendant, it was for the accused person who was just provided with legal aid simply because the other party is represented by the state, which is very powerful. This slide shows you about what happened in the sphere, in international sphere as well. Centering United States of America under the theme Legal Aid for Unmet Needs of Poor, access to justice and legal aid merged, which intensified the application of legal aid. So meanwhile, another concept with regard to justice came into play, which is social justice, which shows the ability of people to realize their potential in the society where they live. So this concept was inspired by Industrial Revolution and socialist doctrine as well. So it is like appropriate distribution of burdens and benefits of the society, which makes access to justice possible, and access to justice also makes possible the social justice. So legal aid is having different dimensions. It is not limited to getting access to justice through free consultation and representation. It is about imparting knowledge. It is about giving information with regard to law. So this totally intensified access to justice is not individual access to justice. It is about knowledge, it is about information, it is about consultation and representation. So this concept basically internationalized at a certain period, basically parallel to the emergence of international law. And Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, and Convention for the Protection of Human Rights and Fundamental Freedoms. There were several articles included to make this access to justice concept internationalized and to get the attention of the international community and make it as a responsible of the states to provide access to justice. And in all these instruments, the basic conventional idea was there that criminal defense was only provided access to justice through legal aid. What happens to the civil matters then? So this was a very conventional type of idea, but in International Conference on Human Rights, which was held in Tehran on 13th May 1968, it was a historic event because you should not limit access to justice and legal aid for criminal matters. You should promote it to an extent to civil matters as well. So legal aid, law and access to justice in Sri Lanka, basically the Constitution of Sri Lanka provides indirect provisions to this, which is not as in India. Article 1 of 12 and 3 of 13, when it read together, you can get the idea that no source of social or any kind of a discrimination or maybe incapacity should not deprive a person from access to justice, which makes the state responsible for making access to justice possible. Legal Aid Act number 27 of 1978 is very important because it institutionalized legal aid in Sri Lanka. So the basic theme or the vision of the Legal Aid Commission is equal access to justice for all, and Section 3 of it provides legal advice and empowers Legal Aid Commission to provide legal advice, funds and obtain the services of attorneys at law for these purposes, and any assistance which needs to be provided for access to justice. So legal aid in practice in Sri Lanka, basically the Sri Lankan experience I'm explaining. Civil matters are attended very much more than criminal matters, basically limited to maintenance, divorce and road accident cases. And developmental legal aid units were established for special groups such as women, children, prisoners. And legal aid clinics, legal advice for public, establishing centers and at courts to provide legal assistance for them, and awareness programs through newspapers, publications, and training programs for public were undertaken by Legal Aid Commission, which is very praiseworthy. So, what are the challenges in enhancing access to justice in Sri Lanka? It's very problematic because the enthusiasm taken by the lawyers or the attorneys at law is at a very minimum level because they lose their financial earnings due to providing access to justice through for free. And centralized judicial powers is another issue in our country, and the selective approach of Legal Aid Commission to attend these matters and lack of awareness of public. Us basically, because we don't know what are the rights that we have and why those are getting violated, and do we have access to justice for free. And insufficiency of funds basically a common problem in Sri Lanka. Judicial activism, lack of judicial activism, and modern technology. It is problematic whether we are using modern technology to enhance access to justice. And the funds allocated for innovative strategies and research is at a very minimum level. So, international standards with regard to access to justice, as I mentioned previously, Universal Declaration of Human Rights, has accepted this as a universal norm. It is not just a human right. And ICCPR has considered it a civil right, and all signatories of the particular convention should provide the access to justice through legal aid. And 6 key topics are considered to be as follows, which makes access to justice possible in a particular country, and if a country can get access to these things, it means that that country is possibly providing access to justice. And I'm going to give examples from the United States of America and India, and adjustments, as I mentioned, aid will be provided for our country. The United States is having access to justice system through Access to Justice Initiative, which is providing access to justice irrespective of the matter, irrespective of the financial capacities of that citizens of the country. And the basic idea that I'm trying to give is justice system of United States is having 3 principles based on that, basically eliminating barriers, ensuring fairness, and increasing efficiency. They have strategic terms which are being implemented to give effect to these principles. And India, which is our neighboring country, we do get most of inspirations from that. Constitutional protection provided for access to justice is basically very praiseworthy. Direct provisions are available, and strong legal system and substantive legislations are there, which the authority could not deny access to justice as the statutory provisions are direct. And for particularly marginalized people, they are providing access to justice through special courts established under the law. And availability of accessible judicial remedial system. Supreme Court of India highly enacted broad aid on this, public interest litigation, and heightened judicial activism, liberalized rules of locus standi, and special courts outside the regime, outside the hierarchy. Especially, we should encourage in Sri Lanka the EDR methods, alternative dispute resolution methods. And my target is to make you aware of access to justice is possible in Sri Lanka, but we need adjustments to be made. So what we can do is, we can get access to justice if we are aware of our rights and if we are aware of our justice system, which should be upgraded and which should be enhanced with all these legal aid assistance. Thank you very much.